No other current witnesses, Your Honor.
Your Honor, if we can approach briefly.
Yes. To the witnesses from whom we have just heard in the form of a proffer, I'll be happy to hear your argument as to why their testimony should be admitted in the presence of the jury.
Yes, sir. The operative statute in this case is 90.404, entitled Character Evidence When Admissible. It states in subsection 1 that character evidence generally, evidence of a person's character or a trait of a character is inadmissible to prove action in conformity with it on a particular occasion, except A, character of accused, evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the trait. Statute 90.405 defines methods of proving character. Section 1, reputation. When evidence of the character of a person or a trait of that person's character is admissible, proof may be made by testimony about that person's reputation. 2, specific instances of conduct. When character or a trait of character of a person is an essential element of the charge, claim, or defense, proof may be made of specific instances of that person's conduct. The state has alleged in count 1 of this case, aggravated manslaughter. And in that definition of culpable negligence, it talks, among other things, I'm not going to read the whole thing, I know the court's aware of it, things like callous disregard, reckless disregard of human life, safety of other persons exposed to its harm, wantonness or recklessness, a grossly flagrant, careless disregard for the safety and welfare of the public, etc. The state, I believe, is alleging in this case that Rhonda Jewell drove to this home and either intentionally left the child in the car or just was negligent in doing so. Obviously, the standard is not negligence, it's culpable negligence. And the way that's defined implies character. Furthermore, in this instruction, it says, the culpable negligence is consciously doing an act or following a course of conduct. As to the course of conduct, obviously these witnesses would be able to testify that Mrs. Jewell was always a good quality caregiver and babysitter for children that she was charged with. Again, this is the state's whole argument, that she wasn't on this day. And we would argue that all those witnesses are relevant to the issues in this case and Mrs. Jewell's defense.
State.
Thank you, Your Honor. 90.4041 says that evidence of a person's character or trait of character is inadmissible to prove action in conformity with it on a particular occasion, and under A, unless the evidence of a pertinent trait of a character offered by an accused or by the prosecution to rebut that trait. In this case, Your Honor, the defense is offering this good character evidence not to prove that she acted in conformity with that good character, but rather to bolster her as a person. This is not an essential element of the crime. If the defense was that The defendant acted in conformity with her good character as a good babysitter, and therefore it was not her who did what happened on July 19th. Then the state would agree there would be an argument that the good character evidence should come in. But that's not what we have here. What we have here is the defense offering this strictly to say she's a good person, that this was a accident. Look at how great and wonderful she was on all these other days except for the 19th. And that is not what is permitted under 404. Moreover, Your Honor, there has already been some of this evidence that has come in during the course of the state's case in chief. So to additionally add more good character evidence from the state's perspective that would be improper would be cumulative. So for those reasons, the state would suggest it would be impermissible and improper.
You get the parting shot.
Yes, sir. Again, the state's made this allegation. They've charged us under aggravated manslaughter. We did not do that. Clearly, the definition of that implies character. It talks about character in a different language, talks about course of conduct, and those are all relevant to the defense and the state's case, and we believe the court should allow this testimony in.
Okay. I'm at this time going to adhere to the previous ruling with regard to those witnesses, which would be to exclude their testimony at this juncture. It may be great if your client is found guilty. That testimony may be great as far as disposition of sentencing is concerned, but I find that it's not relevant at this point. Where do we go next? State has rested.
I'm sorry.
The state has rested. We've disposed of these proffers. Do you have other proffers?
No, sir. No other proffers.
You got any?
No, sir. No other proffers other than Dr. Diamond when he comes. But I think the court has indicated it's not going to change its ruling, but I think I still need to proffer it into the record anyway.
That's correct.
So,
okay. Do you have a witness we can call and get the jury back in?
can we have just a moment?
Yes.
Yeah.
With the only other, we have the witness. I know why you did it.
Now we're going to call Mrs. Rhonda Jewell to the witness stand.
Who?
Mrs. Rhonda Jewell. You want to bring
Call her
it?
to the witness stand. Come on up, ma'am.
You want to get the jury out first, Judge, or?
No, I'll get her up here, then we'll get the jury.
Okay.
You can go ahead and bring them in while she's coming up.
All right. All jury present.
Be seated, please.